Good morning, auctioneers. Welcome to the webinar today. Can you please give me a thumbs up if you can hear me? Thank you so much. Thank you so much. My name is Naledi. I'm the stakeholder relations for the PPRA. I assist PPRA with workshops, seminar, conferences, and webinar. And we arranged this webinar after we got a request from SAIA that their members would want to know the processes of registering auctioneers. And today with me, I have Advocate Deborah Weil. She's the acting executive manager of the licensing and exemptions department here at the PPRA. And she's also a Fidelity Fund claims manager. I'm sure some of you know her already. You've been encountering her on the emails. Advocate Deborah Weil will take us through the presentation today of the processes and the steps of how to register auctioneers, because I'm sure you're wondering, what are the legal requirements around the regulatory of auctioneers and what documentation will you need for the registration. There's somebody who is speaking. Let me mute them. Sorry about that, colleagues. And also how you're going to submit when you register for auctioneer. So she's going to take us through the presentation until you get your Fidelity Fund certificate with the category of auctioneer. So with me today, let me take you through her history a bit. She obtained her BA Law and postgraduated LLB degree at the University of Natal. And Advocate Weil, has been admitted as an advocate for 38 years. And she spent more than 20 years as a prosecutor. And also she worked for the criminal and civil magistrate with the Department of Justice for 11 years. She worked both in private sector and public sector. And she's been with PPRA for many, many years, starting from enforcement and compliance. And now she's heading up the licensing and registration business unit. So with me today, she's going to take us through what I see the hands. We are not going to take questions now. We're going to allow Advocate to give a presentation. Then we will monitor the charts. All your questions, we will take note of them. And the hands, we will unmute you after the presentation. Once she is done, then we can engage so that you can get clarity, and she will try to respond to all of the questions. And if we run out of time, she will still be available on email to take some of the questions. And also we can do meetings afterwards for those who really need a sit down with her, unless it's necessary after. So Advocate Weil, without maybe wasting time, we can start with the presentation. I see you already flagged the presentation. You can take us through. Thank you so much.
Thank you, Naledi. Good morning, everybody, and welcome to the webinar this morning for auctioneers. I just want to check if everybody can see the screen. Naledi, is it visible?
Yes, we can see the screen. Please give us thumbs up if you can see her screen in slide mode. Yes, they can see the screen, Advocate.
Right, thank you. Is everyone hearing me clearly?
Yes.
You hearing me, Naledi?
Yes, I can hear you. They can hear you. They're giving you thumbs up.
Okay, great. Thank you. All right, welcome, everybody. We will be going through some of the information that's important for you in relation to the new Property Practitioners Act and the registration of auctioneers. This is not by any means an exhaustive webinar. The Act is long and it's quite involved in some areas. So it is required that you go and have a look at the Act and the regulations and satisfy yourselves that you are familiar with your duties and responsibilities under that Act. And this will give you some of the most important aspects of it. But obviously we will need to do some more webinars from time to time in order to assist you to become familiar with all important aspects of the property practitioner industry. Right. The new Property Practitioners Act was signed into law by the President in September 2019, but it did not come into operation until the 1st of February 2022, when the regulations were also published. So that is the start date for the operation of the Property Practitioners Act. You will see that under the Act, we now not only regulate estate agents, but we also regulate 12 categories altogether. that operate within the property practitioner space. That was also why our name was changed from the Estate Agents Affairs Board to Property Practitioners Regulatory Authority, or the PPRA. So we now regulate the following categories: estate agents, auctioneers, bond and bridging finance originators, HOAs who perform property practitioner activities, managing agents, property facilitators and intermediaries, business brokers, including sales of franchise and business undertakings, developers who market and sell their own developed property, timeshare and fractional ownership practitioners, property advertising platforms, property practitioners who specialize in collecting and distributing trust money in terms of Regulation 2.4.1. They are called payment processing agents, and attorney employees. I'm going to stop at auctioneers first of all. Auctioneers now operate in a regulated industry. So it's very important that auctioneers are made aware of the fact that they are regulated by statute, by an act of parliament, and by regulations which are passed by the Minister of Human Settlements. That is the ministry that we fall under. And these acts, regulations, and statutes are peremptory. We cannot decide whether we wish to comply or not. They are law, and so unfortunately we have to ensure that at all times we operate within the four corners of the statute, and hence the regulation that is given to the authority to ensure that that happens. The only one which you may need some explanation on in relation to our categories is the property practitioners who are known as payment processing agents, because this might be relevant to you. This provision refers to what we knew previously as institutions such as PayProp, who operate a trust account on your behalf, and they have to comply with certain requirements specifically set out in the regulations. And in terms of that, they are entitled to operate a trust account for other property practitioners and perform certain auditing and trust account duties in respect of those accounts. So if you as an auctioneer have a trust account and you would rather somebody else administer it, or you would rather have someone else register and operate your trust account for you, you can do that. If that entity is registered with us as a property practitioner and specifically a payment processing agent. You will see as we proceed with the webinar that all property practitioners, every single one of them, is required to have a trust account. Whether it's used or not, whether it's got any kind of money in it, you are required in terms of the statute to hold a trust account. That being said, there is a provision in the regulations which allows for property practitioners who do not deal with trust money, do not receive trust money, do not pay out trust money, do not have a trust account, have never had a trust account, and undertake not to accept any trust monies, to apply for an exemption from the holding of a trust account. And we'll see how that can be done shortly. So that's your slide relating to what types of industries within the property sector we regulate. The Licensing and Registration Business Unit is part of the Property Practitioners Regulatory Authority. I'm the acting executive of that department. We have about 14 staff members who do different types of registrations. We also have systems in place in order to register and issue Fidelity Fund certificates. All those industries that fall under the PPA, or Property Practitioners Act, may not operate without a Fidelity Fund certificate, which is valid and current and issued by us. And we'll look at some of those provisions a little more closely in due course. So these are the functions that we perform in our industry. the registration of all property practitioners, the issuing of fidelity fund certificates, or a registration certificate, and the registration certificate is only for attorney employees. In terms of the Act, Section 1 contains the definition of a property practitioner, and included in that definition is auctioneers and also what it calls attorney employees. We do not register attorneys. Attorneys are not property practitioners. They are exempted under certain provisions for those property practitioner activities which they perform within the course of their lawyer's business. But as soon as they operate as a property practitioner for any activities which arise outside their legal business, they must register with us as a property practitioner, not as a lawyer, and they have to have a fidelity fund certificate. However, what the Act does do is it requires all property practitioner attorney employees whose duties, when they are employed by the attorney, consist wholly or primarily of property practitioner activities. For example, the advertising of property for sale in a deceased estate or in an insolvent estate, the sale of property in execution of a writ of execution or a judgment. Those persons who are employed by the attorney must ensure that they are registered with us and they receive a registration certificate and not a fidelity fund certificate. And the reason for that is that they are covered by the fidelity fund of the law societies and not by the fidelity fund of the property practitioners. Apart from registration and issuing of fidelity fund certificates, we also renew fidelity fund certificates of all property practitioners, which have to be renewed by October the 31st by the property practitioner of each year in which the FFC expires. So what that means in practice is that if you hold a fidelity fund certificate, your fidelity fund certificate is valid until the end of December of that year, or the third year that it's issued for, and you are required by the end of October to pay and renew your fidelity fund certificate, failing which penalties can accrue for a late renewal or registration. There's also provision made in the Act for exemptions in terms of Section 4, and exemptions are dealt with by way of the completion of an exemption form, which is in the regulations, which I will mention later. It's called an E1 form, and these are sent to the email address section for exemptions at the ppra.org.za. Please note these are not education or equivalency exemptions, but you don't need to worry about education or equivalency exemptions at the moment because they don't affect you currently. What you do need to worry about is the exemption from Regulation 33, and that we will deal with shortly. Okay, so if you have other exemptions, you want to be exempt from a provision of the Act, you can send an E1 form to that address, and these are also processed and regulated by the Licensing and Registrations Business Unit. You will see there some important information about fidelity fund certificates. Fidelity fund certificates under the new Act are valid for 3 calendar years. That a calendar year is from January the 1st until the 31st of December. However, please note the proviso there, which indicates that unless the first year of those 3 years is also the first FFC that is issued to you. In other words, you're a new registration in the industry. You have registered to get your first FFC. In this case, your first year constitutes the remainder of the year of your first registration and is valid from the date of first registration until the 31st of December of the same year, and that is your first year. Your second year will be the following year, your third year the year after that. So let me give you an example just to clarify this. Let's say you decide that you are going to operate as an auctioneer within the property practitioner industries, and you apply to register and obtain your FFC. And you do that in June of this year. Your first year of your FFC will be this year because you cannot operate this year without a Fidelity Fund certificate. And your validity of that first year FFC will be from the date that you are registered in June and the FFC is issued up until the end of December. So it's not a full calendar year. It's valid from your date of registration till the end of December. That is your first year. Your second year will be 2025, and your third year of validity for that FFC will be 2026. So your 2024, although it's only part of a year, is your first calendar year of validity. I hope that's clear. Any questions, please keep them for afterwards or otherwise put them in the chat. All right, let's move on to some important information for auctioneers. It's important to note that with the registration of auctioneers, just the same as with all other property practitioners, no auctioneer may be registered or operate unless they are registered as a director or an employee of a registered auctioneer firm. Right. So those of you who have submitted requests to register as an auctioneer and been told that you can't do so and given a whole story as to what you have to do and have not quite understood it, let me explain this to you. In terms of the Act and regulations, you always need to operate under a registered firm, which means that the firm that you operate under must be registered with us as a business property practitioner. The director of that firm must be registered with us as an individual property practitioner auctioneer, and any employees of the firm must be registered with us under that firm as employee auctioneers. Okay? Hence the need for a firm to be registered first, along with your director, and the employees to be registered after that. So I've pointed out that auctioneer firms and their directors register simultaneously. And just on an explanatory note, all persons who register and operate an auctioneer firm are designated as directors. All other persons registered under the firm are designated as employees. Now, you will be aware that in the estate agent space, you register as a principal or a full status agent or a candidate, and you are required to upgrade from one to the next as you achieve your various education qualifications, and you have different rights in relation to those categories. Those categories do not currently exist in the auctioneering space. So you do not register as a principal, you do not have to have a principal, you do not register as a candidate, you register only either as a director, which is your owner or operator of your business property practitioner firm, or you register as an employee under a registered auctioneering firm. So a company's directors, as reflected on their SIPC documents, must register as directors of the firm. A CC's members as registered on their CK documents, register as the directors of the firm, and the trustees of a trust, as reflected in their trust deed, must register as the directors of a firm. The caveat to that is that this exists and applies unless Regulation 41.17 applies to these directors or members or trustees. And what Regulation 41.17 says, and I've put it there in italics for you to have a look at, and it speaks here about non-executive directors. This would be non-executive directors, members or trustees, or directors, members or trustees who are finance, marketing, IT or HR directors, or directors who are not directly concerned with the management and oversight of individual property practitioners may be granted an exemption from holding a Fidelity Fund certificate under that firm in terms of section 48(1)(b) and 48(2). And they need to apply for that exemption using the E1 exemption form that I mentioned. So just to give you a practical example, perhaps we have a large auctioneering firm. The auctioneering firm has, let's say, a board of 12 directors. Some of those directors are operational directors. They are involved in the oversight of the business, the management of the day-to-day activities of the business, and the management of property practitioner staff. They must register as a director of that firm, and they must hold a Fidelity Fund certificate as such. Those directors that are on the board who may be purely and simply IT directors, HR directors, finance directors, maybe the accounting officer or whatever, they can apply for an exemption on the conditions contained in Regulation 4117 if they qualify. In order for that to happen, they would need to send in the E1 form properly completed with a motivation, and included in that motivation would have to be a resolution of the board indicating that they are either non-executive directors or that they don't have the authority to operate and oversee the day-to-day property practitioner operations of the business or manage any property practitioners. Okay, so that's how they may be exempted from holding a Fidelity Fund certificate. We come to the important information related to exemptions, and the exemption provisions are contained in Section 4 of the Act. Section 4 permits an exemption to be granted from any provision of the Act or regulations for a maximum period of 3 years, and it may not operate retrospectively. Okay, so it operates from the date on which it is granted, and you cannot obtain an exemption for something that you should have done 5 years ago. Okay. In order to apply for an exemption, you use Section 4 exemptions at the ppra.org.za, and you submit your documents to that email address. Please ensure that you do not use the email address exemptions at the ppra.org.za, as that relates to equivalency exemptions, which is something quite different, and you will not be assisted. It's required that you indicate in the E1 form which sections of the Act you seek exemption from. In the E1 form that you submit, you need to also provide us with a motivation. What will happen is that your application will go before a committee, which is known as the Exemptions Committee. The Exemptions Committee will consider it against the criteria set out in Section 4, subsection 5. So if you want to see what you need to comply with in order to get an exemption, have a look at Section 4, subsection 5. It's quite simple and quite easy to understand. Have a look at it and you'll see the kinds of things we take into consideration before we grant that exemption. And if we are satisfied, then the Committee of Exemptions will issue you with an approval certificate to say that you are exempted. We also need to explain the process of trust exemptions, which I mentioned previously. Now, there is a special provision in the regulations, and it's found in Regulation 2. And this provision indicates that a property practitioner may be exempted from holding a trust account on certain conditions. And in order to obtain that trust account exemption, it is required that you submit the affidavit, which is contained in Regulation 2. So if you look at Regulation 2, you will see that at the end of it, there is an affidavit, a pro forma affidavit, which you need to complete with your own information, which has to be then commissioned by a Commission of Oaths. And that can be submitted to the Audit Department at the audit address that I've put in blue there. with your application, and they will then exempt you from holding a trust account. In the affidavit, you have to make certain declarations, as I mentioned earlier, about not receiving trust money. And you may also, if you do not have a trust account and you believe that you qualify under the requirements of that affidavit, you may submit that affidavit with your application to register to the Registrations and Licensing Department. And we'll tell you how to do that in a moment. So either you get a trust exemption by submitting your affidavit to the Audit Department, or you submit it with your application to register as an auctioneer, and it comes in with your application to register, and we will then deal with it from there. Okay, some more information that is of importance. This is a principle which is very important for all property practitioners to understand and to remember. And this is headed deregistration, dormancy, ceasing to operate, selling your entity as a going concern, or resigning as a director. Now, because we operate in a regulated industry, the regulations and Section 54(9) of the Act advise us what we have to do when we stop operating as an auctioneer. We cannot, as we would do in any other industry, simply abandon the business, stop operating, close our accounts, and go off and do something else. We have to comply with the provisions of Section 54(9) up until Section 54(14). And this requires that you deregister your firm if you are no longer going to be managing and responsible for that firm. Okay? So if you decide that I don't want to operate as an auctioneer anymore, and you decide to close down your business, or if you decide you are selling your business to somebody else, and somebody else is becoming the new director of that business, or if you decide that you're no longer operating as a director of the business that you are registered with, you're going to retire or do something else, and your directorship is going to be removed from the company documents, or even if your firm is no longer going to operate, perhaps you're not selling it, you're not doing anything, you're simply ceasing operations and your firm is becoming dormant. In all of these instances, you remain responsible for compliance of that firm until such time as that firm is deregistered with us or somebody else is registered as the responsible directors for that firm. So what that means is that in those instances, you need to advise us that your firm is no longer operating. You need to request us to deregister your firm. And in order to do that, you must comply with the requirements of Section 54(9). That includes that you close your trust account and you provide us with a letter which explains exactly and confirms that this trust account belonging to this firm has been closed and the date of closure. And I've set it out there for you. You have to wind up and close that trust account, pay out the trust money to the owners. You then submit that letter from the bank confirming that to us. You also submit a winding up audit report from your auditor, which is part of that winding up. And that winding up report must be from the date of your last auditor's report, the date that was covered in your last auditor's report, which would have been the end of your financial year, up until the date when that trust account was closed. You then deregister the firm with us in order to avoid Fidelity Fund certificate fees, penalties, annual audit requirements, and any fines which you would attract for not complying with those provisions. Also remember that if you are a property practitioner and you are a director of any firm and you would like to apply for renew your FFC for that firm, you will not be able to obtain it if you are also the director of a non-compliant firm. The reason for this is because if you have a firm that has trust monies and you have a director or a group of directors who are unprincipled in the way they do business, and they're rolling monies in their trust account, and something goes wrong and they realize that they're in trouble, very often they simply abandon that company and they go and they register a new one. Now, if you come to us and want to register that new company, we will require you to wind up and comply with all the provisions of the Act in terms of the old company or the other company until such time, and until such time as that is done, no FFCs will be issued to you. You also need to remember that any employees of your firm will not be able to obtain their Fidelity Fund certificate if the firm and the directors have not been issued with the Fidelity Fund certificate. Also remember that all natural persons pay for FFC registration and renewals. Juristic persons do not. So the company or CC or firm itself is not required to pay. Its FFC is issued without payment, but the director of the auctioneering firm must pay for his own registration and renewal of an FFC, and his employees must pay for their own also. Of course, if he wants to pay for it for them, that's entirely up to him, but they are required to pay for their FFC. And all firms, although they don't pay a registration fee, are required to pay an administration fee on registration. Some information about FFCs and also about employees who cease to operate as an employee of an auctioneer. As I've indicated, FFCs are issued for 3 years. All employees who leave their employer must inform the authority in writing within 14 days of their change of employment and either register under another employer or they will be deregistered. Okay? Remember that if they don't tell us that they have left the industry, so they're working for one auctioneer, they decide they're not going to be working any longer, they're going to stay at home and do something different, or they're going to go and join another industry. If they don't advise us of that, those employees will be liable to pay for their renewal fees for the following year. They have to advise us by the 31st of October of the year of their current FFC that they will not be operating the following year, and we must then deregister them. They have to do that in writing within 14 days of them ceasing to operate. If they don't do that, they will be invoiced for a new Fidelity Fund certificate for the following year, and when they don't pay it on time by the end of October of the previous year, that will attract penalties in terms of the Act. Please note that these are provisions which are contained in the regulations, so they are there by operation of law. So there I have set it out that they must inform the PPRA before the 31st of October of the previous year that they are leaving the industry, or they are required to renew their FFC before that date for the following year. And that applies to directors as well. Right, we'll talk about fees, fines, and penalties. Registration fees, Fidelity Funds fees, renewal fees are established by statute in the regulations of the PPA. All property practitioners are required to pay a statutory levy to the Property Practitioners Fidelity Fund on first registration. Penalties for late or non-compliance are established by statute under the regulations. And all statutory fees and penalties escalate annually by an inflation-related percentage, which is also set out in the statute. Let me just stop briefly at this point and confirm that the fees which are payable are contained in a fee schedule on our website, You can go in and have a look at them. You will find registration and FFC fees, renewal fees, etc. You will also find administration fees where they apply. So there are 2 schedules which you need to have a look at. The levy for the Property Practitioners Fidelity Fund, which is payable by all first-time registrations, was in 2022, when the regulations came in, an amount of 400 Rand annually. So that is escalated annually by the inflation-related percentage, and it now sits at a little more than that, but it's set out in the fee schedule, which you'll find on our website. I also need to advise you that fines for minor contraventions of the Act or the regulations, and this includes the Code of Conduct, are levied by inspectors, and they do this by issuing a compliance notice under Section 24 to Section 26 of the PPA. So if there is a minor contravention, and that is those contraventions are set out in the regulations, an inspector can come and have a look in your office, can do some inspections, can ask for certain things, and then can say, in terms of the regulations and the Act, you are required to display your Fidelity Fund certificate prominently. You have failed to do so, therefore we are going to give you a compliance notice requiring you to do so, and also imposing a fine of X amount as set out in the provisions of the regulations, which you can pay by a certain date. The authority to reduce, increase, or amend a fine rests only with the adjudicator in disciplinary proceedings. And the adjudicator or disciplinary adjudicator is the one who deals with major contraventions, and that is part of the disciplinary process. So where we have an auctioneer who has contravened the provisions of the Act, there's a complaint that we've received, somebody is unhappy, we have investigated it, the legal department has decided that there is a case to be answered, the auctioneer will follow the disciplinary process, will receive notice of a hearing, will be required to appear at the hearing, can put his case, and can lead evidence, bring witnesses, etc., etc. And at the end, if he is found guilty of any contravention, the adjudicator can impose a sanction, which in terms of the statute is a reprimand, a fine, or in serious cases, the withdrawal of your Fidelity Fund certificate. If your Fidelity Fund certificate is withdrawn, of course, you cannot operate. The authority to impose these sanctions rests with the adjudicator. And also, if you receive a notice, compliance notice, and you don't believe that you are guilty of the fine and you don't wish to pay the fine, you can ask that the matter go before a disciplinary hearing and that the adjudicator reduce or amend the fine that was imposed. You should bear in mind that the adjudicator could also increase the fine that was imposed, since he is not bound by the statutory notice. The contraventions or misconduct for which all property practitioners are required to comply includes any non-compliance with the provisions of the Code of Conduct or the Property Practitioners Act and regulations. The Code of Conduct, let me just stop there for a moment and tell you about the Code of Conduct. It's contained in the regulations in Regulation 34. You will see that at the moment there is a very short section which applies to all property practitioners, and that's only the first, I think it's the first 2 or 3 sections that applies to all property practitioners. After that, the Code of Conduct deals exclusively with estate agents. So those are not applicable to you. Only the general provisions in the first few sections are applicable to you. However, in terms of the regulations, PPRA is required to formulate a code of conduct for all industries, and that will be done in consultation with those industries and the industry bodies. And we will obviously take cognizance of what your codes of conduct are, if you have them, and incorporate them insofar as is appropriate into our own code of conduct. And that code of conduct will then be published and will be applicable to that particular industry. That has not yet happened. So the general provisions of the code of conduct contained in Regulation 34 are currently applicable to auctioneers. Some contraventions, including operating without a fidelity fund certificate, trust account irregularities, displaying a lapsed or false fidelity fund certificate, failing to return money which was earned while operating without an FFC, or using the PPR's name or logo without permission, are all criminal offences under the Act. The Act specifies that they are criminally prosecutable. There are some others, so do have a look at the Act for criminal contraventions where they apply. There are not a lot of them, but some of the provisions of the Act must be complied with and can give rise to criminal prosecution if you don't. Right, we'll move on to the registration process, which I'm sure you're all waiting to hear about. Right, so we've advised that you need to have a firm registered. You also need to have yourself registered either as the director of the firm or as an employee of the firm. So as I've said, the director of an auctioneering firm is required to register a firm by submitting the following documents to the PPRA Licensing and Registrations Department, and that's the address that you're going to use. Manual registrations at the ppra.org.za. And this is what you're going to submit. A business property practitioner application form. Bear in mind, this is for your firm. This should be completed and signed by all the directors of the firm. Secondly, the company or CC or trust documents or your partnership agreement showing the details of the directors, members, trustees, or partners. These are basically your sub-C documents. You also need to submit a bank letter, which is signed and stamped by the bank, confirming the details of a trust account, which is held by the firm, and stating that the account is held in terms of Section 54.1 or 54.2 of Act 22 of 2019, which is the PPA. The section that we've referred to specifies that that has to be noted on your account title. So that's why that must be in your bank letter, confirming that it is an account held in terms of those sections. Alternatively, if you do not hold trust monies, and you will not hold trust monies, you are required to submit, along with your application, a letter of exemption from holding a trust account issued by the PPRA, or an application, as I mentioned, it's an affidavit, applying for such exemption. You are also required to submit an auditor's letter, and I'll discuss auditor's letters a little bit later. It's basically a letter where your auditor confirms that they operate as auditor for the firm. A company resolution is required if there are 2 or more directors, as per your company documents, and obviously this applies with members or trustees if you're referring to those types of juristic entities. And that company resolution must confirm who is acting as the principal of the firm, principal being used there not in the respect of an estate agent principal, but your principal director who is going to be responsible for the firm. A BEE certificate is also required by the Act unless the firm is a sole prop or a partnership. I'm going to stop briefly at the BEE certificate requirement. You may have heard that there's been a great deal of discussion and consultation and argument over what constitutes a valid BEE certificate. The Act, and I'm referring to Section 50, subsection 10 of the Property Practitioners Act, indicates that no property practitioner can be issued with a Fidelity Fund certificate unless he is in possession of a valid BEE certificate. The question then arose, what was a valid BEE certificate? The PPRA considered that valid BEE certificate meant compliant, and that your BEE certificate accordingly had to be compliant with the codes, the charter codes, which mean that you should have at least a level 8 BEE certificate or certification. There was disagreement within the industry as to whether valid included compliant, and therefore there was disagreement as to whether the BEE certificate had to simply be valid in that it was issued by an accredited authority and it was valid for the current period, or whether it also had to be compliant in respect of the charter codes that you had to comply with in order to be BEE compliant. Having obtained senior counsel's opinion on the matter and taken the matter to the minister at DHS and consulting with industry, it was decided that the PPRA will interpret a valid BEE certificate to be a certificate that is accredited, or issued rather by an accredited industry, is valid for the current period, but is not necessarily compliant in respect of charter codes. So your BEE certificate has to be submitted even if it indicates non-compliance, and that will be acceptable for purposes of obtaining your Fidelity Fund certificate. You should be aware, however, that Section 20 of the Act does require property practitioners to comply with BEE requirements and BEE charter codes. So PPRA will have to, in terms of the provisions of Section 20, put in place those programs, those training requirements, etc., which would encourage all practitioners and put them in a position to be BEE compliant insofar as is possible. Those will come in due course. So for the moment, your BEE certificate, irrespective of compliance, is sufficient as long as it's valid, and it must be submitted with your application. In terms of the same section, Section 50, subsection 7, you are also required to submit a SARS tax clearance for all firms that are registered with us. And then, of course, you would need to submit proof of payment of the administration fees. All of those documents go to manual registrations at the ppra.org.za. If there's anything that's not correct or that you're missing out, we will advise you, and you will then receive your Fidelity Fund certificate in due course. We then move on to the registration of auctioneers themselves. Here, directors register themselves individually by submitting their ID documents, individual property practitioner application form completed and signed. And please note that when you look at the application form, it's essential for you to tick or cross or whatever wherever it's needed in every required field. If it's incomplete, we cannot process your application. The director is also required to submit an E1 form along with his application, applying for an exemption from Section 33. The reason for this is the following. In terms of Section 33, the regulations provide that no person can operate as a property practitioner unless they have done two things. The first is completed a manual training or practical training course, which is accredited by the PPRA. And secondly, they have passed a PDE examination, which is your professional designation exam. Now, we have all those things for estate agents. However, our education department does not yet have them for auctioneers. So it would be impossible for auctioneers to comply with the requirement to have completed a practical training course and completed a PDE exam when there's no such thing available. So in order to get past that provision, you need to apply for an exemption from that provision, which would be an exemption from Section 33. Now, just to stop at education requirements for a moment. Regulation 33 sets out the standards of training that are required for property practitioners. It says that the Property Practitioner Regulatory Authority must establish educational standards of training for each industry. We must also establish a practical training course and a professional designation exam for each industry. At the moment, the only one that is currently in existence is for estate agents. So there are no minimum standards of training required for directors, or for auctioneering directors, that is, or for auctioneering employees. So until those are in place, obviously you need not comply with them. However, the provision, as I referred to earlier, which indicates that you need to have your manual training, your practical training course, and your PDE exam to be able to operate, it remains in force. And so because of that, we need to exempt you from that. And that we will do basically for the asking. It says you have to apply because the provisions of the Act require you to apply, and the provisions of the regulations also. But all it means is that you complete your E1 form, you send it in with your application, and you say, I'll ask that I be exempted from Regulation 33. And the reason, because they'll ask you for a reason, is that the PPRA is not yet able to provide us with the PDE exam and the course material for a practical training component. And therefore, I'm unable to complete it. Okay, so it's a very simple process. And then proof of payment of your registration fee. Remember that individuals who are natural persons must pay a registration fee and an FFC renewal fee when the time comes. So that's what your directors are doing. Your employees are going to do something very similar. They're going to submit an individual property practitioner application form, completed and signed, same as the directors did, the same E1 form, a letter of employment, which is signed by your director and by the employee, and which includes your reference number of the director and the firm. Okay, and that is to ensure that we register you under the correct firm and that you have the correct director who is responsible for that firm. Proof of payment of your registration fee, and there is the address to submit that to. Some general information on fees, employment changes, and name changes. As I've indicated, the registration of a firm is free as far as your FFC fee is concerned. You just pay an administration fee. All other registrations, you see your schedule of fees, which is on our website. Your employment change is free unless you have been deregistered. All right, you'll remember that I said that nobody can be registered with us unless they are allied to or registered under a firm. So when you are no longer an employee of a firm and you want to go and be employed by another firm, you have to advise us, as I said, within 14 days. And you have to then apply within that period to be registered under your other firm. So when you come to us and you say, please note, I've resigned from that auctioneer and I'm now going to be employed by this one. Here is my letter of employment. Here is all my documents for me to register under that firm. Please, will you register me? That will not cost you anything. Okay? But if you have told us, or your employer has told us, that you are no longer working for this firm, and it's not accompanied by a new application to register under another firm, then we will deregister you as we are required to do. And if you come back to us later and say, okay, I'm now joining the industry again, and I'm now going to be employed by another firm, this is the name of the firm, you are going to pay for your Fidelity Fund certificate again. Okay, and that is because you have been deregistered. Employment changes require submission of all the same documents as for an employee registration. And we do need your ID document again, so we can be sure that it's the correct person who is requiring it, and you don't come back to us 6 months later and say, but I never changed, I never moved, and I never asked you to move me. All right, very quickly to stop at auditors or registered directors, please see the audit manual on the website. Our audit department has drafted an audit compliance manual, which is found on our website, and it's very comprehensive and it's very helpful. So please have a look at it. You need to know what is contained in that document. All firms must submit their annual audit report in the format prescribed by the Property Practitioners Regulatory Authority within 6 months of their financial year end, and submit this to the PPRA in good time, that's within the 6-month period, or penalties will accrue monthly. Okay, and those are expensive, so you don't want to do that. All firms, in terms of the Act, also have to have their business accounts audited within the same period, but you are not required to submit them to us. It's only your trust audit that we require within the time period. However, if you get an inspector who comes to inspect you, which he can do in terms of the Act, he may ask for that document. But there is a proviso. Section 23 provides that firms without a trust account, and remember, that's a firm who has been properly exempted from having a trust account by submitting his affidavit, and with a turnover of less than 2.5 million per annum, does not need an auditor, and he can have his financials, his business financials, reviewed annually by an independent accountant instead of having to pay an auditor to do that. Okay. Bear in mind, this is only if your turnover is less than 2.5 million and you don't have a trust account. If you have a trust account, you must have an auditor, because an auditor is the only one who can audit a trust account. That brings us to the end of the webinar. The queries, if you have any, can be sent to Naledi at the PPRA or to our registrations, auctioneering and other industries registrations administrator, Tokozani Ndlovu, and he will assist you with any queries that you have. You can also approach our call center, and that is the call center number. And then, of course, we've got our social media addresses there if you require them.
Okay, thank you so much, Advocate Vile. That was informative, especially even for us, because this legislation is new. We have hands. I will go to the chat. Let me see. On the chat, we don't have questions. I will allow Bianca to be the first person to ask a question. I've given you access. Please unmute yourself and ask Advocate a question. Bianca? Or maybe she's struggling. I'll come back to you, Bianca. Let's go to Monique. Monique, please unmute yourself and ask a question. Monique? Can you hear me? Or maybe they can't hear me. Let me try Sonja. I'll come back to Bianca and Monique. Let's move to Sonja. You can ask your question.
Good morning, Naledi. Good morning, Advocate Deborah. We really appreciate this webinar to our members. It was very insightful. So I really want to just thank you for that from all of our members. I've got 1 or 2 questions that I just want to ask. With regards to the trust account exemption, the CPA does stipulate, the Consumer Protection Act does stipulate that an auctioneer must have a trust account in terms of their regulations. So I want to know if the PPRA has taken this in consideration when they have done the trust account exemption section.
Okay, when Parliament passed the Act, they passed it not only for auctioneers, they passed, and of course the regulations as well, they passed it for all industries. So this is a blanket exemption which applies to all industries. You will be aware that if you are regulated by another act or another piece of legislation, then, and that has its own requirements, you are required to comply with that. Okay? So if, for example, and we've had this before under companies who are closed corporations, in terms of the legislation that governed closed corporations, they were not required to have their financials audited every year. They were entitled to have them simply prepared. Okay? Our act did not allow that. So we had many closed corporations coming to us and saying, but the legislation on closed corporations doesn't require us to do an audit. And our response was, well, that might be so, but you are also an estate agent, and therefore you also have to comply with our act. And our act says that you do have to be audited. Okay, so it's the same situation here. Our act does not require property practitioners to have a trust account if they have been properly exempted, and it sets out the criteria for exemptions. If there is another piece of legislation that governs you particularly, you obviously have to comply with that legislation.
Okay, perfect. Thank you for that. My other question is, if you deregister, if you are as an employee as an auctioneer at an auction company, and you decide to leave that auction company and go to another auction company, will you then deregister and register under the new auction company?
No, what you will do is you will submit a request for an employment change. Okay? So you will submit a new application to us with a letter saying that you are now employed by this new company. So you'll need a letter of employment from them. You will also need correspondence from yourself confirming that you are no longer employed with the previous company and asking us to remove you. So we will then remove you from that company and we will do an employment change and add you to the new company. Okay. However, please note, as I said earlier, that if we do not get that request to register you under the new company, and in the interim, your previous employer or you advise us that you are no longer employed there, then we will deregister you, and then your move to your new company is no longer an employment change, it's now a re-registration.
Okay, noted. Thank you. Then I want to know, with regards to the education exemption, there is a new qualification registered with SAQA for auctioneers, and NQF level 4 qualification. It's under the SAQA ID 120670. Will the PPRA take that education in consideration?
I'm sure the education department will do so when they decide what qualification standards are required for auctioneers. I know that is the process they're involved with at the moment, and they will be consulting with auctioneers in relation to what would be an appropriate standard of training. And if there is such an auctioneer's NQF4 qualification, I'm sure that would probably be the one that they would require. But I can't say, I'm not in education. There is an executive in charge of education who will follow that process. But I would imagine that he would do so.
Okay, so for how long will this education exemption be valid for?
Education exemption is valid for 3 years, the same as any other exemption, unless we specify a shorter period. So if you look at the exemption that you get, we might give you an exemption for 3 years, alternatively, until such time as the education requirements are there and you have been given time to comply with them, whichever is the shorter, whichever happens first. But generally, we will do it for 3 years, and bear in mind that we can withdraw a registration, rather an exemption, at any stage if it becomes necessary to do so for good reason. And if we have a new education standard of training which comes out for auctioneers, and there has been a period of time given for you to comply with that, we may then withdraw your exemption and say you should now have complied with that requirement under the standard of training requirements.
Okay, then my last question. If auctioneers, so most of our members do sell property either as private treaty or on auction. So if an auctioneer sells property as a private treaty, they will have to be registered as a property practitioner estate agent and register as a property practitioner auctioneer to sell on auction. Is that correct?
Yes, that's correct. The provisions of the Act indicate that each and every industry must have a Fidelity Fund certificate and be registered in that industry in order to operate in that industry. And there's nothing to stop you from being registered in multiple industries, okay? You will bear in mind that your registration under each industry is going to have different education requirements. It may have different requirements as to whether you need to have a trust account or not. There's all sorts of differences in relation to how you may operate. And so also your code of conduct will be different. So it's required that you register separately in each industry that you operate in, and you obtain a Fidelity Fund certificate for that industry. Now, you can use the same firm to register as an estate agent. You can have any big firm that you have or that you may have, or any small firm for that matter. You can register as an estate agent. You can register as a managing agent. You can register as an auctioneer, all under the same firm. You will just have 3 separate Fidelity Fund certificates.
Okay, and if you are registered as an auctioneer firm and as an auctioneer property practitioner, are you allowed to sell properties via private treaty or only on auction?
No, only on auction. By private treaty, I assume you mean ordinary people off the street coming in and saying, I want to sell my property, please can you find me a buyer? And you then find a buyer and enter into an ordinary contract of sale or offer to purchase, etc. And in those circumstances, you have to be an estate agent.
Yes, or if you have, or if you receive an offer prior to auction and you sell it prior to auction.
Yeah, if you've advertised it for auction and you receive that prior to auction, my view is that it's probably part of the auction process. So if that's what you're doing, you shouldn't need to get an estate agent registration as well. As long as it's part of the auction process, you've received it to auction, that's your mandate, that's your instruction. Somebody comes in and says, okay, I will buy it before and I'll give you whatever the fee is, the amount is that you are supposed to recover. And you do that as part of the auctioneering process prior to the actual auction. That would be all part of your business model. So I can't see that that's a problem.
Okay, because in some instances, auctioneer will receive an instruction to sell a property, but the instruction will be to see if they can get offers, and if no offers materializes, then go to auction. So those offers, will that then be seen as private treaty or also part of the auction process?
Yeah, if it's not an instruction or a mandate to auction, then it's an estate agent activity. So then you would need to operate as an estate agent to do that.
Okay, thank you.
Thank you so much. And also, Sonja, I sent you the presentation. You'll share with the members the same presentation that Advocate presented now. Let's go back to Bianca because you struggled earlier. Let's try again, Bianca.
Hi guys.
Hello.
Hello.
We can hear you.
Yeah, it's Alec. It's not Bianca. I registered with Bianca's laptop.
Okay.
Hello.
Please ask your question, sir.
Yeah. What I wanted to ask, it's already I answered. I've covered everything. Then I'm fine. Thank you very much.
Okay, thank you. Let's go to Clive.
I think you've answered the question. If you're doing letting and you're doing private selling and you're doing auctioneering, do you need 3 certificates?
Yes, you do.
Thank you very much.
Okay, thank you, Clive.
Thank you so much.
Danica?
Hi, morning. Can I just clarify something, please? I've had an original question, but back to the private treaty on Sonia's question. Now, the private treaty seems to be confusing someone, but we're not saying that it is a private individual sale, somebody that comes to you and says, sell my property. Auctioneers like us only work on liquidations and etc., insolvencies and whatnot. But we get an instruction from the appointed liquidator, trustee, or receiver liquidator, for an example, that says to us, market the property for 3 months. If the property is not sold within the 3 months, please proceed to auction. Now, this, in my opinion, still falls under the PPRA. Because it's not a private sale as such. It's still under instruction as to the process this property has to go through before it can actually sell on public auction. So in my opinion, private treaty contracts on liquidations and insolvencies, etc., should still remain under the PPRA. Do you agree with me on this?
You mean, and you mean under auctioneers, not under the PPRA?
Correct.
PPRA is all industries.
Yeah,
look,
auctioneers.
You have to look at the definition. The definitions in Section 1 of Property Practitioner specify various activities. And the activities of an estate agent are receiving mandates in order to sell somebody's property. And the sale is to find a buyer. And that's what they do. Now, if your mandate is to find a buyer and to advertise the property for sale, then you are performing the functions of an estate agent. Okay.
All right.
If your mandate is to auction, and you are going to auction the property, but in the process, somebody comes along and says, "I want to buy it," or you are advertising it, saying, "I've advertised it for auction. I've got a mandate to auction, but anybody who's interested can come and approach me beforehand." That, I think, technically falls within audit. But as soon as you are advertising a private sale, in other words, you're advertising one property which you are selling to the public, you're performing an estate agent operation. So right. I don't see how that falls under auctioneering.
Okay, and then just to ask, under the exemption pertaining education, now yes. This is where it becomes tricky, because now with the PPRA we can request an exemption on the education until it's basically established. But when you registered now, for an example, at the EAAB, do you as an auctioneer can you still request an education exemption? For an example, we maybe have our EAAB exams done and the NQF4, but the directors are required under EAAB to have an NQF5. Can an exemption then be done because you're auctioneers, and or is there, or what should be done there if in the event of a private treaty?
Okay, so they asked if you want to register as an estate agent, as you've said, you would need to comply with the estate agent educational requirements. If you are unable to do so, and your business is mainly auctioneering, but you are going to be performing some property practitioner or estate agent work in the course Correct. or around that, which appears to be the case, you would have to apply for an exemption in terms of Section 4 from the education requirements of an estate agent, and you would have to then motivate that. Okay, so this is a different kind of exemption application, everybody. This is not the one I was referring to, where I mentioned the practical training and the PDE requirement. What you're going to do then is you're going to do a separate exemption application, and you're going to motivate it on the basis that I want to be exempted. I want to register as an estate agent, but I am currently an auctioneer. I'm registered as such. Most of my business is auctioneering. In the course of my business, I do, however, obtain instructions from some of my clients to market a property first before going to auction. For that, I need to register as an estate agent, and therefore I ask for an exemption. And you can ask for an exemption from one of two things, and you can actually do it in the alternative. So you can actually say, please exempt me from registering as an estate agent, which I should do because I'm doing private sales. But because it's mainly an auctioneering business, and this is something that's done in the course of my clients, please can I be exempted from registering as an estate agent and allow me to do this within my auctioneering business? Or alternatively, if you don't want to allow me to do that, please can you exempt me from the requirements of the estate agency education standards of training for a period so that I can register as an estate agent and legally do these kinds of transactions. It's probable that if you get the exemption, and as I say, I can't tell you if you're going to get the exemption or not. That's something the exemption committee will decide. But if they give it, they will probably give it to you for a period and say, whoever your director is must obtain the standards of training that are required for your estate agent principal at some stage,
right.
and give you time to.
That
Okay.
makes sense. Thank you so much.
Okay. Thank you so much. Advocate, I have a comment from Daly. I think she's listening in. She's saying there's a difference between deregistration and employment change. If you are moving from one company to another, then that is defined as an employment change. Maybe you had Daly, somebody asking that question. However, if you are intending to exit or leave the industry, then you have to apply for deregistration. Advocate Vile, I have a question from you from Mark. It's coming from the chat. He says, if you have a trust account for your estate agency, can you use the same trust account for your auctioneering firm under the same business name already registered at the PPRA?
Yes, you can.
Okay, thank you so much. One from Solette, I think we did answer this one where they're asking if to confirm property agency already registered with PPRA, should you register another one? I think this one you've covered it. I have 3 questions, Advocate Vile, from Koti.
Yes.
Koti wants to, but you did present on BEE. She's asking, has there been any news on the legislation on the BEE of small businesses in handing over 51% of the company, which the minister had put into place? Is it better for a business to change PTY and CC to a sole proprietor company?
Okay,
Advocate.
I cannot. I can't advise you on what the BE requirements are and what you can do or can't do to become compliant under that. That is a separate regulator entirely. But in relation to the BE certificate, as I've indicated, the BE certificate now has to be a valid certificate, which is issued by a valid and accredited authority, and it has to be current, so it has to apply to the current period. It does not have to be compliant with BE codes. It doesn't have to be compliant with the 51% requirements, etc., for you to get a Fidelity Fund certificate. So whether you change to a sole prop or not, it's not really going to make a difference, because if you're a sole prop, you don't need a BE certificate, correct? But you are still required under Section 20 to comply with BE legislation and codes. And that will obviously happen in due course, and the rollout of that program will come. But for purposes of issuing the Fidelity Fund certificate, you either don't submit one if you're a sole prop, you don't have to submit one, or you submit one that is valid but not compliant, or not necessarily compliant if you are a juristic person. So it's up to you to decide whether you think it's better for your business model to operate as a sole prop or as a company or CC. But I can't see that the requirement for a BE certificate, as it has been defined now, is very onerous on a company or a CC.
Okay, then I think also she's asking, what should we do with the interest in a trust account? I think also you touched on the exemptions to be exempted from trust account, Section 54. So that one, I think maybe because...
Let me deal with, Naledi, let me deal with the interest on trust accounts, because I didn't really deal with that. So that's something that you will see in the audit pamphlet, which Thomas, who is our education manager, has published. But briefly, in terms of the previous act, interest on trust account could be dealt with in one of 2 ways. First of all, if you had an agreement with the owner of the trust money, excuse me, that is your buyer or your lessee or whatever it is, that any interest had to be paid to them then obviously at the end of the period when you pay out that trust money, the interest on that trust money accrues to that particular person. But that had to be in writing. And in terms of the current legislation, it also has to be in writing. If it's not in writing, under the old acts and regulations, that interest had to be paid over to the Estate Agency Affairs Board. The Estate Agency Affairs Board allowed you to keep 50% of that in order to offset the costs of your trust account. Now, under the new Act, we have no express provision in the Act itself relating to the trust account, monies, the interest on the trust account, but we do have something in the regulations which indicates that interest on trust accounts should be paid to us. We have agreed with estate agents in the estate agent industry particularly that we will continue to accept 50% of the trust account interest, and the other 50% can be kept by the practitioner. And I'm quite sure that that is what audit will be applying in respect of auditors as well. They will simply require auditors in terms of their trust account audit report that comes in. The auditor will say this is the interest that was earned, this is the interest that is payable to the owner of the trust money in terms of agreements that say that. The rest of the trust money is X, and 50% of that is hereby paid over to the PPRA. So that's basically the provisions at the moment.
Okay, thank you so much for that. Advocate, I have a last one from Godi because she had 3 questions. Does the firm and the director have the same digit number if only one director exists?
No, your firm always has a firm number, which in your instance will be AUF, which is for auditing firm, and then your numbers, all right? That will be assigned to the firm. Your director will have AU and the numbers assigned to him. So your director will always have an individual reference number, which will take us to his own personal portal or his own personal profile, and the firm will have its own number. And then each employee has their own AU number as well when they register.
Oh, okay. Thank you for that. I have a hand from Val. Val, you may ask your question.
Hi there, it's Val from Ian Wild's Auctioneers. I'm a director of the company, but I don't manage any property practitioners. Do I apply? I just want you to verify, can I apply for exemption where education is concerned?
Yes, you can apply for the exemption, but have a look at the provisions of the section that are printed in the slide, and you will see whether you comply with the wording that's contained in that. Because I don't know what else you do apart from not regulating actual property practitioners, but just have a look at it. If you qualify, then you certainly can do so.
Thank you very much. Thanks.
Do you have other directors, or are you the only director?
We have Ian Wiles. Well, he's a principal. Then we have our bookkeeper, who's also a director. So okay. I'll just look at the provision and just clarify whether we are exempted or not. Thank you so much.
Okay, fine. Thank you.
Okay, Advocate, I have Vanessa. She says, please advise where we may obtain the firm and principal application forms. Are registrations open at this time? And is there a timeline or cut off for registrations?
Okay, registrations are open at the moment for auctioneers and for all industries, in fact. You can get the forms on our website. Or you can phone the call center and they can email one to you. And there is not a cutoff date. You are required to do it immediately. Obviously, we are going to give time for it to be phased in. In that, remember, please, everybody, that our FFCs have a 30-day turnaround time in terms of the statute. So if you apply, it's likely to take 30 days. So as long as you have applied, there shouldn't be any issues in relation to operating without that. And we will set a timeline in due course. But for the moment, we are registering everybody as they come. And we are in the process. Obviously, this is a new process for us. So we're in the process of monitoring how long it's going to take, whether we're going to accommodate everybody, whether we need to give you an extended time period to apply and to get your FFC, etc. but for the moment, we are registering, so send in your application.
Do we have the forms on the website, Advocate?
Yes, we do. They are
Oh,
on the
okay,
website.
because yes, okay. I have another question from Nando. If it's a newly formed company without any income as yet, can an affidavit be submitted regarding BEE, or I think he wanted to say, is there still a requirement to have issued via an accredited rating agency?
You can submit the affidavit if you don't, if you won't be able to get it. And generally you can't if you're a brand new company. So you would submit your affidavit, and that would be sufficient for the first requirement. And from there you would then have to submit us a compliance certificate.
Okay, thank you for that. I have Daniel. Do auctioneers that are only selling movable assets required to register with the PPRA, or is it only property-related auctioneers? But I think it's a repeated question because you did answer, but if you want to maybe say it again, Advocate.
Sure, it's only for immovable property. So if you're an auctioneer of movables, we don't need you to come and talk to us at all. We have no control over you. It's only if you sell immovable property. Or
Okay,
businesses,
thank you so
of
much.
course. Please remember businesses as well. Okay, if you're selling businesses, then you come to us as well.
Okay, thank you so much. We no longer have the questions from the chat, so I think we exhausted all the questions. I don't see the hands, so I take it that okay, there's another hand that's coming now. Koti, let me just see who's raising the hand before we close. Koti, please ask your question before we close.
Hi, I would just like, can we get contact details for Deborah, or that my director wish to speak to her? Is it possible?
A direct line, we will email you. Advocate will email them the direct line.
Yes, and if she wants my email address, then I can always give the director a call.
Sonia has the details. I think she will also share on her side.
Okay.
Yes. So I don't know, Koti didn't unmute. There was someone else asking that question. I don't know if you want to still ask before so that we don't cut you. Koti, going once, going twice.
Hello, can you hear me?
Okay, yes.
Can you hear me?
Yes.
Thank you very much for taking the questions before. Only under the trust monies. I have a group of agents that's working together on as a maxi group. And we had these questions beforehand, and that's why I have these three questions together. But under the trust account interest, there was questions, do they automatically pay the interest over to the PPRA? And if so, or do they wait for an invoice? And then the second one is, what bank account do they use for that? Because that notice made mentioning of the PPFF's bank details. Should it be the normal PPRA, or should it be the PPFF's? PPFF's? I did inquire about it previously, and I didn't receive a explanation, but I only received the bank account details confirming the PPFFs. So the agents want to know, is that the account that they need to use for the interest? And what reference do they need to use?
Okay. The payment of trust money is something that resorts under the audit department in conjunction with the finance department. So I don't have details for you of what bank account should be used, or at what stage they invoice you. That's something that finance has to advise. So I can find that out. If you give me your email address, I can give you the information, or Naledi can send it to you. But as far as your audit payment of trust interest is concerned, that amount comes from your auditor. So your auditor, when he submits the audit report, should tell you, where at the same time when he gives you a copy, you should be able to see that's the amount that I owe to the PPRA. And then if you pay it before you get an invoice, it doesn't matter. It will go onto your profile as soon as they get the amount that's due and they invoice it. But you can wait for the invoice, I'm sure. But let me confirm that. As far as the number that you use, you will use the firm's firm number. So you will use the AUF number of the firm when you pay the interest.
Okay. And but the account to use you will confirm with us.
Yeah, we'll have to let you know. It will be, as far as I know, it's the Fidelity Fund account, so it should be into the Fidelity Fund account. But I will check what that account is with finance.
Thank you. I will put my email address now in the chat. Then,
Okay,
Naledi,
sure.
please send it. Thank you very much, Advocate.
Yes, we will see your email address. Let's go to Nico.
Thank you. Good morning, Deborah. Thank you for all the information. It really is helpful. And I'm hoping that this is going to be shared with Sonia so we can just share it with our members. Just going back with regard to the different designations and the FFCs. So I would like.
Sorry, sir.
We're getting, I can't hear
Sorry,
you.
sir. There's somebody. Nico, sorry about that.
Not a problem.
Please, I'm just trying to check who's doing this. Nkensani Rapunga. Nkensani Rapunga. Nkensani Rapunga, please mute yourself. Let me try to disable them. Sorry about that. We apologize about that. Please continue, Nico.
No problem. So with regard to, I think Deborah, what I'd like to do is maybe see if we can get legal opinion with regard to invitation. So what that is
Sorry, I lost you.
It's an
You broke
invitation
up
to.
completely. I didn't hear you. You broke up, and I didn't hear.
I'd like to, through Sonia and yourself, in collaboration with yourself, to get a legal opinion or an opinion with regarding to invitation to submit offers, which effectively is a process whereby an auctioneer sends to buyers to submit competing offers, which I'd like to argue that is part of an auction process. Especially when invitation, an instruction from a liquidator or sellers to get competing offers instead of going to an actual auction. Before the auction, many of the auctioneers send out an invitation offers, which I think can be regarded as so. In other words, what I'm saying is, do you then have to be registered? Do you have to have as an estate agent for that, or can that be under the FFC of your auctioneering status as a designation there? That's the first thing that we'd like to maybe just have a look at, especially when it comes to that process. The second thing that I'd like to just mention is with regard to the interest on the trust monies. Correctly, already there's a I'm just trying to get my thought here. There's already a decision taken with the estate agents regarding the 50-50 interest. So my request is that there is a practice note that is sent out to all designations, including auctioneers, with regard to that. I don't know if there is a practice note that has been sent out to us. If we could just get a practice note with regard to that interest, so we could send it to our members too. Thank you. That's more or less what I have to. So thank you.
Okay, thanks, Nico. Okay, certainly when it comes to things like what you talk about, an invitation to submit offers, that sounds to me very much like an auctioneering type process. And so, absolutely, we can sit down and have a chat about that and say, all right, well, are we happy that kind of process falls under auctioneering, which it sounds like it does. It sounds like it's quite different to simply putting a picture in the paper of a property and saying, this property is for sale, which is what estate agents do. So we can discuss that.
That's something that. Yeah. Okay.
So yes, invitations to submit offers, I think that may very well be able to come under your auctioneering auspices. But yeah, we can talk about it and we can do a practice note on that. That is something that would come from me. As far as the interest on trust money is concerned, that is a practice note which has to be issued by the audit department. And obviously they can only do it if they're satisfied that that's acceptable and that everybody is happy with that, or give people an opportunity from the different industries to discuss it if it hasn't been settled with them. So I will pass that on to audit and ask them please to either issue a practice note on that or to engage with auctioneers to settle on some sort of a practice note that's acceptable.
Thank you. Thank you very much, Deborah.
Thank you, Nico. Let's go to Danica. It's the last question from Danica.
Sorry, I actually just wanted to add to Nico. I would definitely like to be part of this process because that's the argument I tried to make earlier. He just used better wording, I think. When back to the private treaty, it's a condition of sale that's required to be used when not on public auction. But it definitely is an invitation to submit an offer, which is only a process done by an auctioneer, not an estate agent. If we can perhaps get more information or elaborate on that, at a later stage, because there is a difference there.
Yes, on the basis of what Nico said, it's quite clear
Yes.
that there is a difference. So that's what I said.
Okay, so do we need to just contact you on this to further elaborate and explain the process, or how will this be done?
If you want to liaise with Nico, Nico, I'm sure will contact me and we can have a discussion on that. We can either arrange a meeting or and anybody who wants to attend can do so. I'm happy to do that and we can see so if you want me to send out an invitation, that's fine. If you want to arrange something through Nico, whatever suits everybody, and we can have a discussion. We can have some of our other legal experts there as well, and we can come to some sort of arrangement as to where that cutoff line is.
That'll be great. Thank
Deborah,
you. If you can
thank
do
you.
the invitation from yourself.
Yes, Nico.
Deborah, we'll be running through Sonia. Sonia will have all those answers, and Sonia will be contact you. I think that's the easiest
That makes
for
sense.
everyone.
Okay.
Thank
perfect.
you.
Okay. No, thank you so much, Advocate Val, for the presentation. And thank you to all the auctioneers that attended the webinar and all the questions that came through. And with the meeting, we will communicate with Sonia. We'll check Advocate's diary. And we'll also invite our audit department, compliance department, and enforcement to join in the meeting so that we can give clarity on this matter. The presentation, we send it to Sonia in the morning. Sonia, please share with the members. We can circulate it. We're going to download the recording. It's going to our YouTube channel, PPRA TV, so that you can go back to it and listen. We're going to have more webinars. Next week, we are meeting with managing agents. We're going to meet with timeshare. Then on the 13th of September, it's all the industry. If you want to join in again, if you remember a question, you can still contact us, email me. Sonia has my email address, Advocate Vile. If you want to know more dates, we also do physical workshops that are ongoing. We're going to contact you and we're going to announce the dates on our social media. Thank you, everyone, for attending the webinar today. We appreciate. Thank you, Advocate. Bye-bye.
Thank you. Thank you, everybody, for participating. We appreciate that.
Thank you. Bye.
Bye-bye.